Yesterday, the Supreme Court announced a 6-3 decision in Trump v. United States that establishes new presidential immunities and sends the case against Trump over his attempts to maintain power after losing the 2020 election back to the district court to decide which charges and evidence against him remain admissible considering these new immunities. The decision has sparked intense debate, with some, including justices on the court, claiming the Supreme Court had turned the president into a king, while others argued that Trump opponents are unnecessarily freaking out about the Supreme Court making precisely the kind of reasonable decision that it exists to make. I'm going to try to help you understand the decision from a voter's perspective, and then I'll provide my personal opinion on the decision as a voter. This decision is fundamentally about whether a former president can be criminally prosecuted for things they did while they were president. But it's important to remember that the Constitution doesn't offer immunity to the office of the president at all. The very idea of official immunity, which you're about to hear a lot about, is an invention of the Supreme Court. This actually came up during an oral argument in April when the prosecutor arguing on behalf of the special counsel, Michael Dreeben, was discussing with Chief Justice John Roberts the court's concern that the ability to prosecute a former president could have a chilling effect on a sitting president's decision. Roberts told Dreeben, quote, "The fact of prosecution was enough to take away any official immunity," end quote, saying that subjecting former presidents to prosecutions violates official immunity, to which Dreeben replied, quote, "I would take issue with the idea of taking away immunity. There is no immunity that is in the Constitution, unless the court creates it today. There certainly is no textual immunity," end quote. And then later, quote, "Nothing like that ended up in the Constitution for presidents, and that's because one of the chief concerns of the framers was the risk of presidential misconduct," end quote. In other words, you can't take away something that doesn't exist yet, and until this decision, official immunity for criminal prosecutions didn't exist. The justices went on to question Dreeben on his perception of what the limits of official immunity should be, but whether such immunity is textual wasn't disputed. This decision isn't rooted in an originalist interpretation of the Constitution. In summary, the majority decided that official immunity depends on the category of the president's conduct. Just Security put together a helpful infographic to illustrate this. First, the decision sets forth two broad categories of presidential conduct: official and unofficial. Unofficial conduct is always subject to prosecution. Official conduct might be subject to prosecution. If the official conduct is under the president's, quote, "conclusive and preclusive core constitutional authority," end quote, then the president's immunity is absolute. Otherwise, the official conduct should be presumed immune, what we're now referring to as presumptive immunity, unless a prosecutor can show that prosecuting the conduct would not, quote, "pose any dangers of intrusion on authority and functions of the executive branch," end quote. If a prosecutor can show that no such dangers are posed, then the official conduct in question is prosecutable. Now the special counsel needs to return to the district court and argue that the charges against Trump clears this bar for presumptive immunity. Before this decision, this bar only existed for civil litigation, and the test for immunity sought to strike a balance between executive authority and public interest, as outlined in Nixon v. Fitzgerald, which was a case in which a U.S. Air Force contractor, Arthur Fitzgerald, sued Richard Nixon for unlawful termination, claiming that Nixon had fired him in retaliation for a testimony Fitzgerald made in front of Congress. In Fitzgerald, SCOTUS decided that the president is immune from civil litigation for official acts. However, in this decision, the court expanded that immunity to protect the president from criminal liability in addition to civil liability, and removed from the test for immunity public interest, saying that presumption of immunity can only be overcome by proving that scrutiny would pose, quote, "no dangers of intrusion on the authority and functions of the executive branch," end quote, removing the public interest standard altogether. Furthermore, the court decided that prosecutors cannot bring evidence regarding the president's motives when trying to overcome presumptive immunity. In other words, the courts must assume that the president is performing official acts in good faith and not with legal intent. In summary, the court expanded the protections granted in Fitzgerald to include criminal acts and significantly raised the bar for clearing presumptive immunity, which in effect makes it much more difficult, if at all possible, to hold former presidents accountable for their behavior while in office, so long as that behavior is considered an official act. It's worth noting that Justice Amy Coney Barrett did not join the majority in their decision to raise the bar for presumptive immunity. The majority summarized their view thusly, quote, "At a minimum, the president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the the executive branch, end quote. We will know more about the practical implications of how the court interprets this standard, which it left exceedingly vague in this decision, if and when the prosecution against Trump makes its way back to the Supreme Court. Case in point, does something like Donald Trump arranging an illegitimate set of electors and attempting to submit those electors to subvert the outcome of a free and fair election count as an official act, or can it be prosecuted as criminal obstruction of an official proceeding, as special counsel Jack Smith is seeking to do? The Supreme Court refused to decide on that in this decision, saying that it was out of the scope of Trump's appeal. By the way, this means that the case won't be decided until long after the election, unless of course Trump wins the election and squashes it. Justice Sonia Sotomayor articulated the concerns of the minority in the dissenting opinion, and she doesn't mince words. She says, quote, "Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. Because our Constitution does not shield a former president from answering for criminal and treasonous acts, I dissent," end quote. She's pointing out that the court is expanding an immunity that it invented and isn't found in the Constitution. She says that the decision, quote, "invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law," end quote. She cites three errors she thinks the court is making in its decision. First, she says that the expansion of immunity to include, quote, "core constitutional powers," end quote, is wholly unnecessary because the indictment in question does not bring any such powers into question. Second, she says that the court lacks a basis for establishing official acts as immune regardless of whether the immunity is absolute or presumptive. And third, she says that the court makes evidence regarding official acts inadmissible, which prevents the government from arguing that official acts clear presumptive immunity, which is nonsensical. After all, how can the government argue that an official act isn't subject to presumptive immunity if it isn't allowed to use anything the president did during that act as evidence? To summarize the rest of the dissent, Justice Sotomayor says that the framers intentionally created an office of the president that isn't above the law, which is exactly where the court just placed it with this decision, completely disregarding the public interest in favor of the authority of the office. She ends her opinion with words that may well become among the best known of any SCOTUS opinion ever, quote, "With fear for our democracy, I dissent," end quote. Now my take. If this decision didn't make the president like a king, it made it a lot like an emperor, in that a sitting president can seemingly rest assured that they can disregard the law so long as they're acting in an official capacity. I agree with Justice Sotomayor that there exists no bright line that delineates, quote, "conclusive and preclusive core constitutional authority," end quote. The courts might go on to hold a strict and limited view of what is considered official, but there's no indication in this decision that it intends to, and there's no insights in this decision as to how it would. Furthermore, I don't buy the basis for the distinction to begin with. The concerns over chilled executive decision-making feels like entirely contrived and motivated reasoning. I don't see a good reason to expand Fitzgerald to include criminal prosecutions. If you want to protect good faith official acts by the president from civil litigation, where the bar for guilt is much lower, then maybe. But criminal behavior is by its nature not done in good faith and doesn't deserve immunity, so as long as the president is equal to everyone else under the law. Of course, the job of the courts is to determine what behavior is and isn't criminal, but this decision essentially abdicates that authority when it comes to former presidents. It's basically the Roberts courts deciding it for all future courts. The concerns over the executive's capacity for the use of force are obvious, and they're being talked about everywhere, including in this decision. But what about corruption? I can't see a reasonable case to be made that the Supreme Court didn't just greenlight the president participating in all sorts of corruption. After this decision, how could accepting bribes for official acts ever be prosecuted? How could using the office to enrich oneself financially by funneling taxpayer money to personal accounts ever be prosecuted? Which, by the way, we already know Trump did, but how bad would it have been if he legitimately had no concern that he might ever be prosecuted for doing it improperly? He would have used the office as his personal bank, further enhancing his desire to never give it up. Furthermore, what if a POTUS uses official acts to funnel money to entities owned by Supreme Court justices? This decision, particularly when considered in conjunction with the Chevron decision, has created an alarming incentive for quid pro quos between the executive and judiciary branches of government that is completely free and clear from public oversight oversight or accountability, which completely undermines, if not destroys altogether, any semblance of separation of powers we had left. And I'm not intentionally trying to freak anybody out here, but my concern extends way beyond this. The branch that is least accountable to the public just massively bolstered its own power by giving itself the authority to determine which presidential behavior is subject to immunity from criminal prosecution. We already saw in 2000 that the SCOTUS is comfortable deciding who the president is on behalf of the people. Donald Trump's whole plan was to push the election to the Supreme Court and give them the opportunity to decide it again. Given current demographic trends in the US, there will continue to be more opportunities for SCOTUS to choose our president, an office that now governs at the pleasure of the judiciary branch along with the legislature after Chevron. The court has created a situation where it can potentially decide who the president is and for how long, who then decides who sits on the Supreme Court in turn, and the court just dismantled any ability the public had to hold anyone accountable for any corruption during the process. It's never been more important to ensure that a man like Donald Trump doesn't become president of the United States. However, this is fundamentally about separation of powers. Even to those who incorrectly say that we're a republic, not a democracy, SCOTUS just opened the door to lose both. For my entire life, concerns over totalitarianism and dictatorial rule have always been focused on the president. I fear that the ball we took our eye off of was the Supreme Court's Chief Justice. John Roberts just established judicial supremacy for the foreseeable future. Our government is different after this decision, and whether for better or for worse is out of the hands of the people. We are now squarely within the arena of harm reduction. If the people are ever to claw this authority back, it will require decades of judicial activism that we will need to have started yesterday if even our grandchildren are able to see it realized. In fact, this is where I draw the line with President Biden. In 1857, the Supreme Court decided Black Americans had no rights in federal courts and that Congress had no right to legislate slavery, effectively illegalizing Abraham Lincoln and his party's platform. He and his party went to war with the Supreme Court in response. They reorganized the judiciary and added a justice to the court. They then passed a law illegalizing slavery in direct defiance of the court's decision. Lincoln said, quote, "The candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal," end quote. The Supreme Court backed down. This is what the current situation calls for: lawfare. If Biden doesn't have the stomach for it, he needs to clear the path for a candidate who does.